In a perfect world, insurance companies would always do the right thing. Yet in reality, the industry harbors a dirty little secret. People are giving them money for something they will never receive. What that really means is they're selling uncollectible insurance. Insurance companies rule our country. They control our banking. Look at AIG, too big to fail. They own Wall Street. They catch a virus and Wall Street has diarrhea for a week. And when interest rates fall and their investments earnings plummet, then they run to Congress and scream tort reform. Lawsuits are killing us, they scream, and those greedy trial lawyers are to blame by filing frivolous lawsuits and convincing ignorant juries to dole out obscene verdicts. But ironically, what you don't know until now is that insurance companies regularly and deliberately invite lawsuits whenever the cost and hassles for a third-party claimant look to exceed all potential for recovery. Rather than just doing the right thing, too many insurers prefer to play a game of litigation chicken, a frivolous lawsuit strategy in reverse. Don't like it? Sue me. And while insurance companies play rough with consumers, they play even rougher with each other. Take the process of subrogation, for example. Here you have one insurance company making a claim against another. Rather than the sue me response, the greetings afforded a subrogation claim usually start with a two-word expletive. Still, that does not make this game right whether played against consumers or other insurance companies. A dollar saved owing only to a claimant's sense of pragmatism and threshold for litigation is not a dollar earned in any traditional sense. It is more like a dollar stolen, and it happens all the time. Today, the Insider Exclusive investigates and exposes Insurance Exposed, and how investigative books like Allstate Insurance McKinsey Report, published in David Bernadelli's From Good Hands to Boxing Gloves, with its 12,000 PowerPoint slides, exposed Allstate's in good hands, zero-sum economic game, otherwise known as Allstate gains, all others lose. And in the years since it began implementing McKinsey's strategy, these companies' profitability shot through the roof. For more than a decade, Allstate Insurance Company fought to keep under wraps this smoking gun and other documents that describe how the insurer had made money by reducing payments to some policyholders. Allstate was making an average of $82 million a year in pre-tax operating income, and in 10 years after the McKinsey plan rollout began in 1995, Allstate was making an average of $2.4 billion a year in pre-tax operating income. $82 million a year to $2.4 billion a year in pre-tax operating income in just 10 years. That does not happen unless they're cheating. There's no place for that to come from unless they're underpaying claims. Similar figures can be assumed for State Farm and all the other bad faith insurance companies out there. There's no denying the facts. The proof is in the profits, and the McKinsey slides are the smoking gun.
The Insider Exclusive meets with David Lilienstein, managing partner of DL Law Group, and Katie Spielman, who have seen many innocent, hardworking people become victimized by their own insurance companies, all in the name of greed. And because of that, they are driven not only to get justice for these victims of injustice, but to make sure that all policyholders get 100% what their insurance companies promised and what they paid for. Plus, get it without hassle and on time. This is the Insider Exclusive, live from San Francisco, California. It is my great pleasure to introduce David Lilienstein and Katie Spielman to the show. Welcome to the show.
Thanks again for having us, Steve.
Good. We understand, because we've done other shows with you before, that you primarily specialize in insurance cases representing policyholders who have a legitimate policy, but their insurance company just decides not to pay them, right?
That's right. At the DL Law Group, we are insurance law experts, all insurance, all the time. All we do is help policyholders who have problems and disputes with their insurance companies.
Right. And after you handle their cases, oftentimes they end up paying them anyway. But I just want to get it out in the open that one of the reasons that insurance companies decide not to pay or to give a person a hard time to pay their legitimate policy is because they know a lot of people will just go away. Isn't that right, Katie?
Yes, that's true. The vast majority of insurance consumers who do have a claim denied are never going to follow up on it, and certainly very unlikely to get a lawyer. And so the insurers are playing the numbers game that they can get away with denying these claims and never have it come back to haunt them.
So this area of the law is called bad faith insurance. But my question to you, David, is this is a pattern of conduct that a lot of insurers engage in, right?
It's a pattern of practice. I mean, people get their claim denied. They feel like they can't fight City Hall. And these carriers, they do this all the time. They know people are going to go away. It is a pattern of practice specifically designed to save money.
So this is the question I've always wanted to ask any lawyer that represents people in bad faith insurance cases, and that is this. If this is a pattern of conduct that a lot of insurance companies do for the sole purpose of hopefully having these policyholders just give up, why isn't there more regulation of the insurance companies to make sure that if they violate, legitimate laws, that they aren't put out of business, for example?
Well, it's a great question. Part of it is because insurance commissioners nationwide, many of them are appointed by the governors. Many of them are in the pocket of the insurance industry.
What does that mean, in the pocket of the insurance?
It means insurance industries do make campaign contributions, and they have the ear of the regulators. And they make sure that the regulators do not pass the kinds of laws that would help consumers. And let's be clear about this. If a law is proposed, what happens? 50 insurance lobbyists are there. You know what lobbyists are, right? They're there to represent an interest. The insurance industry is organized. They'll have 50 or 100 lobbyists there to make sure the bill doesn't pass. On the consumer side, maybe there's one or two attorneys who will go there.
Right. Let's talk about make sure the bill doesn't pass. What they do is representatives, elected officials, have terms generally of what? 2 years, correct?
2 to 4 years, depending on the state.
Takes money to run a successful campaign, right? Insurance companies have a lot of money, don't they?
They sure do.
So when lobbyists are there, they're saying, what? You look with favor on our perspective, and we'll make sure you have enough money to run for re-election, correct?
The lobbyists are giving campaign contributions. The lobbyists are saying, if you're going to pass a law like this, here's the language we would like to see in this law. Or, we don't like this. We think this is bad for business, and we want you to make sure it doesn't happen.
And you bring up a good point. A lot of times lobbyists write legislation, don't they?
They sure do.
And the elected officials really don't know what's in it, do they?
5, 10, 15, 1,000 pages, and politicians read the first 5 maybe.
All right, now let's talk about some of the tactics that insurance companies try to use against policyholders not to pay them. What are some of them?
Well, I think the first thing an insurance policyholder should know is that an insurance claim is not an attempt to get to the truth, right? Are you disabled or are you not disabled? Were you hurt? Were you not hurt? Did this healthcare is this healthcare need legitimate or not? This is about saving money. Insurance companies are not interested in the truth. They're not interested all too often in a reasonable investigation.
What you're really saying, Katie, is that when an insurance company sells their policies, they have really no intent of following through. Is that right?
Right. The business model of insurance is based on collecting premiums and paying out no or minimal claims, and so minimizing the amount of money that's going out. So insurance companies are designed around denying claims, and they have armies of physicians that they employ in-house that will characterize your medical records in a way that allows the insurance company to create a justification to deny the claim, even though it might be completely the opposite of what your own treating physician is telling you.
Do you remember in the movie The Rainmaker with Matt Damon? And Matt Damon had the president of the insurance company up on the stand, and he said, how many denial letters did you send to this policyholder? And finally he got an answer like 6 or 7, right? And the final letter that they sent was basically said, don't you get it, stupid? we're not paying this claim, right? Remember that in the movie?
I do remember that, yes.
Yeah, basically that's the attitude. Now, not all insurance companies are bad insurance companies, okay? But the great majority of them are, aren't they?
The problem is that the ones who are doing things that they shouldn't do, they get market share, they have more money, they're more profitable, so they create a pressure on the other companies to do the same thing. I mean, let's be clear, an insurance company is going to walk in and say, hey, we made an honest mistake. We're sorry. We should not have denied your claim. It was an honest mistake. Well, it's neither honest nor a mistake.
And they're going to offer less money, aren't they?
Unreasonably undersettling claims violates the California insurance code, and it happens all the time.
Yeah, and let me give you an example. Down when Hurricane Katrina hit, they had a lot of people lost their homes. And let's say a home was worth $100,000. Person's out in the street with his family. He's living in a FEMA trailer, right? And he needs money, doesn't have money to buy food. They'd come along and they'd say, hey, would you take $10,000 now?
They will dangle a check in front of people, and they know that 90% of the time people will take that money.
Now, for lack of a better term, this is unethical?
To say the least.
Technically illegal, isn't it?
It's technically illegal, and yet it happens.
But they get away with it.
They get away with it.
And they continue to get away with it.
They do. And let's be clear, the insurance industry will say all too often, look at all the claims we pay. We pay hundreds of thousands of claims. Well, that's like saying, look at all the banks we didn't rob.
Yeah, right. Good one. Yeah. Now let's talk about a specific case, because we handled this before. Logos Missions. Tell our audience a little bit about what Logos Missions is, what type of insurance that they were peddling, and what exemption that they thought they could successfully use as a defense.
This is one of the ones that really got us going. Logos Missions sells healthcare policies.
And it's a Christianity program. It's a Christian program, right?
They sell it
It's a religious program.
Sell it through the churches. Yeah. And they try to characterize.
And it's healthcare.
It's healthcare. You're getting a healthcare policy. They want to say this is Logos Missions. We'll say it's not insurance. We do not sell insurance. These are voluntary contributions, except it's every month. And if you don't make it, you don't get any coverage.
Right. In other words, if it looks like a duck, walks like a duck, smells like a duck, it's a duck, correct?
Well, this was a heavily litigated case that we had at the DL Law Group, and the court ruled that this was insurance.
Now, there is an exemption for religious organizations selling insurance that doesn't require them to follow insurance regulations, yes?
Well, sort of. What they sell is that religious organizations are exempt from the personal mandate, the individual mandate in the Affordable Care Act. And Logos Missions took advantage of that to scare people into buying their policy.
The policyholder in that case of Logos Missions was Deacon Choi. He was a deacon in the church, right?
Yeah, he was a member of the church hierarchy.
And after he bought the insurance, I remember he got cancer of the mouth.
He had mouth cancer, and they tried to deny him based on a pre-existing condition.
And his medical bills were $300,000, right?
He had a lot of medical bills, yes.
And you successfully settled that case.
That case has been resolved to the mutual satisfaction of all parties.
Right. I'm just kind of curious, is Deacon Choi still a deacon in that church?
He's still a member of the church, and he's doing great.
Now, you had another case that we covered against Mutual of Omaha.
Yes.
Tell us about that case.
Well, this was a disability case. We at the DL Law Group litigate a lot of disability cases, and this was a particularly egregious one in that the individual was so disabled that she died.
Yeah.
She literally died from her disabilities.
Yeah.
And the insurance company tried to get off paying anything to anyone.
And that was Mutual of Omaha.
Mutual of Omaha, yep. And they tried to contend, or they did contend, that that particular insured waited too long to file her claim.
Yeah.
Unfortunately, she was sick. So sick that she died. Can't deny that. And they say, well, you waited too long to file your claim, so we don't owe you a dime, because that's what the policy says, and you didn't follow the letter of the policy, so goodbye. That's what they tried to say.
And what happened in that case, by the way?
That case was settled to the mutual satisfaction of all parties.
Katie, when a policyholder gets a letter of denial from their insurance company, what should they do? In plain, simple, best instructions.
Well, first of all, when you get a denial letter from your insurance company, don't take it at face value. It might not be accurate. It might not be correct. It very likely is not correct because, like we said, insurance companies are looking to deny claims. So you might have a valid claim.
Even if you have a valid claim, right?
Exactly.
Okay.
So the first thing you should do is call a lawyer, call an expert, someone with specialty in insurance law, because it's a very specialized area of practice. At the DL Law Group, we talk to people every day who are in that very situation, free consultations, just to talk people through their rights and options and next steps. And it's very important to do that quickly because there can be really tight timelines on enforcing your legal rights.
And what are some of those tight timelines that you talked about?
Well, for instance, if your plan is governed by ERISA, if you have your insurance policy through your employer, you might have only 180 or even less days to file an appeal after you get that initial denial letter. So it's very important to get a copy of your policy, but call a lawyer right away.
And that's the law, isn't it?
That's correct. There's
180 days. If you don't file a claim or an appeal, then you are out of luck forever. Is that right?
If it's an ERISA claim, that's exactly right.
Okay.
And that's the problem, because by law, you have to read your policy. By law, you have to understand your policy. Who understands an insurance policy?
Right.
Talk to us. We can help you understand that.
Now, most people, their only contact with an insurance company is their agent. You know, they had this nice agent that they knew from someplace, and that person generally does not know the policy, do they? They're a salesperson,
right.
aren't they?
The agent their job is to sell you the policy, to get you to buy the policy. They're not in the business of warning you about the limitations of the policy or even understanding what the policy means.
And they have probably been instructed. I mean, I would not put it past them that management has told the agents, listen, we don't want to pay these claims, right? We want to reduce, besides that, you're going to get a big bonus. I know they do this. I know they do this at the end of the year for less claims paid, right?
That's right. There's incentives in the insurance company that rewards their employees, their agents, their claims managers for denying claims.
So let's say they contact your law firm, okay? They said, I think the insurance company's screwing me over, okay? What do you do next?
We have a series of questions depending on the kind of insurance and the kind of claim,
Right.
and where the person is with their claim. And we'll ask a bunch of questions.
What do you mean where they are with their claim?
Well, has the claim been denied once? Sometimes people call us, they say, you know, I haven't been paid and I should have been.
But there are insurance companies that don't respond at all.
Well, that's why we get involved.
So
That's-
then we get this 180 days, we're getting to the deadline here. What happens, we should add that if your insurance company's not responding to you at all, because there are insurance companies that do that, right?
there are absolutely insurance companies who won't respond at all.
So the message should be that if you file a claim and you don't hear from the insurance company or you get a denial letter, you should contact a lawyer within 30 days.
The message is always don't wait.
Right.
You will never hurt yourself by contacting an attorney
Right.
or just asking questions early on.
Okay.
The problem is when people call us and it's too late, we can't help them if people have waited too long.
Okay.
We can say you have more time. We can say don't be worried in this particular instance,
Right.
but we can also say it's so good that you called us now because you're being proactive. We can help you.
Right. And what do you look at when you look at cases to handle? Because you probably got a lot of people that contact you.
We like to look at the policy.
Yeah.
If there is a denial letter, we like to look at the denial letter. If there's medical evidence, because it's a healthcare case or a disability case or even a life insurance case, we want to see some of the medical evidence.
Are there insurance companies that are worse than others, Katie?
There are some insurers that are particularly bad actors. We see a lot of cases out of Unum Group, which is one of the largest disability insurers in the country.
Yeah.
The Standard is another insurance company that we see quite often around here. But all insurance companies really have this same motivation to maximize profit and minimize the amount of dollars that are going out.
I want to bring up a point because I did a story with Unum, okay? And oftentimes insurance companies will have experts who are contract doctors, okay? They are not employees of the insurance companies, right? And they will contact this contract doctor that they're paying $40 or $50 an hour. We want an opinion of this case. And I have actually been involved with a case where the opinion came back, denying the claim. And when that doctor was deposed, he was asked, did you have any facts in front of you? Did you look at any records? He said, no, none was sent to me. Then how did you arrive at this opinion that you should deny the claim? And the doctor said, I just know these things. Okay, now, the insurance company's defense in these cases, well, we didn't know he would do this, right? He's not an employee of Unum, right? So, they can get rid of it. They throw these people under the bus too, okay?
We always have a look at what information the insurance company provided to the doctor.
Yeah.
And that's the tip of the iceberg, because what happens is 3 treating physicians say someone is disabled or someone needs a health care. The insurance company gets one of their doctors and they issue an opinion, and then another one of their doctors looks at that opinion and rubber stamps it, and maybe a third person looks at it. So the insurance company says, hey, we have 3 doctors who say this person doesn't deserve this claim to be paid, despite the treating physicians, despite the medical evidence, despite the history. But the carrier can say, well, we have three doctors who on their own say, and some courts and some judges give these doctors credit for their opinions when they've never even seen the person, they've never examined the individual, they don't even have all the records.
Right. And you would think that would be unethical, because it is, right? But they still do it, right?
There's a whole industry out there of doctors who work for insurance companies.
Yeah. I want to bring up one point, the case that we did a story on. Unum, not too long after that, signed a consent decree with 46 attorney generals not to conduct this same type of practice, and agreed to review 10,000 other policies that had been denied. Now, I asked the question, did they redo this? Are they continuing the same practice? They're continuing the same bad faith? And they never reviewed those 10,000 policies.
Well, it's even worse than that. It's sort of in the everything old is new again. Katie and I have just written an article about Unum in particular, and we talk about the fact that this company has said, we're reformed. We're not doing all those things. We made all these promises to credit treating physicians and do X, Y, and Z. The evidence suggests that nothing has really changed. The leopard spots have not changed, and Unum is still out there denying legitimate claims. And let's just say Unum is not the only bad one out there. You know, as Katie said, there's others. Optum, Mutual of Omaha, Liberty Mutual. There's a lot of bad actors out there, unfortunately.
So you brought up a term that a lot of people are not familiar with, ERISA.
Yes.
A lot of bad faith disability cases are handled under ERISA. Explain for our audience what ERISA is and some of the problems you have in trying to get justice and get something paid under ERISA. What is ERISA?
So ERISA stands for the Employee Retirement Income Security Act of 1974. It's a federal law. It governs any employee benefit. If you have a health care plan, a disability plan, a life insurance.
So almost everybody working that has health care through their employer is governed by ERISA.
Very special rules, very easy to miss the deadlines in ERISA, and ERISA tilts the playing field in favor of the insurance company.
Now, the interesting thing is when it was originally written, legislated in 1979, it was designed to protect the employee. But what has happened in the last 40 years?
ERISA, 1974, I'll correct you there, was originally passed to protect pensioners. This is when baby boomers, some of them were retiring, their pensions were getting raided and mishandled, and Congress passed a law to protect them. That has since been expanded by specific Supreme Court cases to now cover any employee benefit, and that's the problem.
Yeah, so in other words, legislation was written, and it's been supplemented and revised by court cases where the original legislation intent is no longer there, correct?
Exactly. For example, nothing in ERISA says that you don't get a jury trial. Jury trials are fundamental, they're a constitutional right, and yet if your case is governed by ERISA, you don't get a jury trial. That's the way the case is involved.
It's before a judge.
It's before a judge.
Okay. Now, what are some of the procedural differences between a jury trial and an ERISA case?
Well, in a jury trial, you have all of the rights that you would have if you took any other civil case to court. So you have the right to present the facts of what happened to you to 12 of your peers, and they get to decide for themselves based on the evidence whether you're in the right or not. With ERISA, you're just conducting a bench trial before a single judge, a federal judge, who is going to decide based on your, really, you're limited to the administrative record in your claim file with your insurance company.
Okay, for our audience, in simple English, limited to the administrative record, which means what exactly?
It means that the insurance company tries to decide all the paperwork that gets considered.
That goes before the judge.
Plaintiffs' representatives, we are prevented, in large part, from bringing in new evidence, from conducting depositions, from getting company doctors, from seeing how many times the insurance company...
This is a kangaroo court, basically.
That's a good way to put it. Well, the judges certainly wouldn't say that. Judges do their best. But the fact that insurance companies save hundreds of millions of dollars by classifying cases as ERISA cases pretty much tells you all you need to know.
So why haven't things been changed? Why hasn't new legislation been introduced so it makes it on a fairer scale?
Well, I'm happy to say that slowly but surely, thanks to the intrepid efforts of many plaintiffs' attorneys, policyholder representatives, some of the laws are slowly changing. The big changes haven't happened yet. I think we would have to have a new regime in Congress to do that. And I think ERISA is so complicated that it's really hard to explain to some legislators why this law needs to be changed.
Okay, I also want to bring up another point. At the end of the day, if an insurance company denies a disability claim, at the end of 6 or 7 years, litigation, the whole 9 yards, you're appealing and everything, they only have to pay what they originally would have had to pay 6 years before, right? Very hard to get punitive damages, correct?
Well, under the ERISA laws, there is no such thing as punitive damage.
So in other words, if they had to pay $1 million, 6 years later, they'd have to pay the same $1 million, right?
They might have to pay a little bit of interest, but yeah, that's the problem with ERISA.
Okay, so there's no incentive to settle the case or, do the right thing until it's run its course, correct?
The ERISA limitations are a very big problem
Yeah.
for
So why do insurance companies do this? Why? Because they want to hold on to the money, right? Invest the money, right?
Right.
If you've got hundreds of millions of dollars of claims that you've denied, right, legitimate claims, you can make money with that, right?
Yeah, they're making money hand over fist, investing money that they don't have to put in their reserves. They don't have to set it aside to pay claims because they're denying all the claims. So they can invest that in the market or in other ventures and
They sound
make
like
even more
crooks.
money on it.
They sound like crooks.
They really are stealing from their customers, their consumers who've thought this is a company that I can trust, that I'm putting my faith in. When people buy insurance, what they're really paying for is peace of mind, that if something did happen, that company's got their back, and the fact is they don't.
So this show is about helping those who are unaware of what insurance companies do. That they deny claims. They like to deny claims. And I don't want to sound like a negative person, but it's the truth. And you're right there at the forefront every single day with these type of insurance cases, right?
We see some of the most egregious insurance denials imaginable.
Is there anything else that both of you would like to add to policyholders out there right now who are sitting with a denial letter right there in the living room, who don't know what to do and what they should do other than just call you? What should you tell them to do?
Just know that you have rights, know that you have options, educate yourself, call an expert, call a lawyer that knows insurance law, and don't take the insurance company at their word. Understand that there's business motivations behind that denial letter and that you very likely have a valid claim and you should follow through.
My advice to any insurance policyholder who thinks they have a dispute with their insurance company is don't walk away. You can fight City Hall. Talk to the right attorney, whether it's a DL law group attorney or some other expert in the insurance business. Contact an attorney, understand your rights.
A lot of people think when they contact an attorney, they have to pay them money up front. These are cases, you're a plaintiff's attorney. In other words, you take on cases, don't charge the client until and if you succeed in getting the money, correct?
Yes, we are more than happy to be paid by the hour, but if somebody can't afford to pay their attorney, we will work on a contingency. We only get paid when we get a good result for you.
All right. I want to thank both of you for spending time with us, and let's hope this message gets out to people.
Thank you so much for all the work you do, Steve.
Thank you.
Okay, you're welcome. Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.